was an AFS student like years ago, and I've came back a lot of times. But in this specific case, we're not talking about Maine the state, but Maine the ship, yeah? The battleship Maine, which was anchored in Havana Harbor. It was destroyed by an explosion, and there were a lot of victims, like 200-ish, 200, next to 300, 259 people died. So it was between the US and Spain, which was, they were already in strain at that time. They were, already in deep with other disputes. So they were, specifically for Maine, they were having a disagreement about the interpretation of evidence between US delegates and Spain delegates, right? And then they want, okay, let's just solve it with the Hague Peace Conference, specifically for fact-finding of, this dispute. So they made the peace conference delegates to also talk about it, and then they decided, okay, let's just make a team of inquirers, inquiry team, that then they should handle only questions of facts and not questions of law. And finally, that neither the creation of a commission nor the implementation of its finding should be regarded as obligatory. So initially, inquiry's team results or reports are not binding in 1899. And then the next case after this, after the main case that was discussed also in length by Merrill, was the Dodger Bank inquiry. If you read that specific case, it's somehow evolving the evolution of the inquiry activities itself, right? So again, it's two countries. In this case, Russia and Japan. So the Russian captain was on their way to Baltic, to the Far East, for war, the Russo-Japanese War at that time. And then they felt like being attacked, right, by a fishing fleet next to the Dodger Bank. So out of, well, of course, panic when you didn't do anything and then suddenly you felt like people attacking you. So the Russian captain, admiral at that time, decided to fire this fishing fleet, right, for about 10 minutes, and then damage a lot of stuff. And before the matter became more complicated, international diplomacy at that time by France, was making a push for both countries. Why don't you just make an inquiry team based under the Hague Convention? So the commission, the inquiry commission, found that there had been no torpedo boats, right, among the fishing fleets that was thought to charge upon the Russian. But however, in the report, they were also saying that the findings were not of a nature to cast any discredit upon the military qualities or the humanity of the Russian admiral or his squadron. So it's merely facts. What they found, that they didn't find any torpedo, any bombs that is outside, the use of the fishing trawlers. So, okay. The Dodger Bank case was somehow best practice example of inquiry, because after the report was submitted, both countries accepted the report, and Russia made payment to Britain for the damages, and the incident was and then closed. But not all cases are as successful as this one. And then after the Hague 1899, the evolution of the inquiry activities came to the 1907 The Hague Convention. So the first incident covered by this convention was off the Tunisian coast during the Turkey-Italian War in 1911-1912. So although France was neutral in the war, Italian government strongly suspected French vessels in the area were involved in shipment of Turkish contraband, like Turkish weapons. So this is like, it became more and more like spies movies, like all of these cases, which is, I think, pretty cool. Considering, all those spies movies that you watch might have, been real in international law. So this then escalated when the French mail steamer called Tavinano was arrested by the Italians, and 2 other vessels were fired on, according to the Italian, in the high seas. But according to the French, it was in the Turkish waters. And then they decided, okay, let's just use 1907 convention and settle this through with, inquiry commission. And the main question that was asked to be resolved by the commission was consisting of whether or where was the controversial incidents occurred, whether it was in the high seas or whether it was still in Turkish waters. Tunisian water. So the commission's finding, it was clear that even though the arrest of the Tavinano ship vessel was in the high seas, but the firing accidents were certain to take place in the Tunisian water. So the significance of Dodger Bank case demonstrated the value of inquiry in diffusing an explosive situation, because when you present the facts by a third uninterested party, and then you sort of bring down the emotion volume. And then in the Tavinano case, it showed that in other circumstances, this specific report from Inquiry Commission can be provided as basis for subsequent arbitration. So, so those are the significance of the 2 landmark cases, Dodger Bank and Tavinano case, for 1907 convention. Okay, and then we go forward to Tiger, right? I kept wanting to say Tigger, but it's not Tigger. Tigger only happens in Winnie the Pooh, and here is Tiger, the vessel, right? Submarine. So during the First World War in 1970, German submarine pursued and sank a Norwegian ship called the Tiger in the northern coast of Spain, right? Again, it's almost the same with the Tafinano. They think that, Norwegian ship was bringing weapon for Spain. etc., etc. That's why, part of it was, distrust. And again, if you distrust them and you don't ask them, but you fire them at those times, I think. So here the Tiger Inquiry Commission was headed by neutral, a Danish chairman, and then the question was whether the arrest of the tiger was, in high seas or in Spanish water, right? The tiger, the significance of the tiger as a case, it was the first case in which parties went to the international inquiry, and they agreed to accept the report of the inquiry commission as binding, right? In the previous cases, we never had that, but for this tiger cases, they decided, both Norwegia and Germany, they agreed that it was binding. So it's a departure from the previous The Hague Conventions. And then the U.S. also, after World War One, or right after 1911 to before World War Two in 1940, they have several treatises that documents procedures in inquiries, right? So they call it the Taft or Knox Treatise of Arbitration, right? It laid down the organization and procedure of the commissions and governed by relevant provision of the 1907 The Hague Convention. So there are several cases under this Knox Convention, the Knox Treatises, right? The first, the most famous one, is the Red Crusader inquiry. Again, it's about a ship. When you see cool names in international law, your first assumption would be that it's a name of a ship because they name their ships crazily. Maybe it's like the Indonesian way of naming trucks, like truck drivers. They would name their trucks and put crazy writing on the trucks. In 1961, the Danish fishery protection vessel encountered British trawler of Red Crusader, the name of the British trawler, close to the Faroe Islands with its fishing gear in the water, right? So the Danish captain thinks that the trawlers were fishing and it was illegal to fish there because it's the Danish water, and they want her to stop. And they arrest the crew of the ship. And then, just like in the movies with Tom Hanks and what is it? Oh, Captain, My Captain. I can't remember the title. But, after they get captured and they were put in the crew of the Red Crusaders were put in the Danish ship, they fought on the scene, and eventually they could broke free of, the Danish, and even abducted the Danish captain. And then they sort of flip the situation and take control of all the ships and bring everything to Aberdeen. So, the Danish patrols were decapitated by British fishermen in this case. Of course, Danish government couldn't take this nicely, and British government also wanted explanation. What happened? Why are my fishermen suddenly, being captured and then, recaptured? So they set up a commission to make sure that everything that happened, the facts are out. So the commission, like, did their job, and there was no proof that Red Crusader were fishing uh, in Danish waters. The Red Crusader was arrested, but the skipper, having changed his mind, attempted to escape and to evade the jurisdiction of an authority which he had at first rightly accepted. In the open fire after the escape, the Danish commander exceeded legitimate use of armed force, and because circumstances did not justify such violent action. Okay, and the British naval officer made every effort to avoid any recourse to violence between the Danish vessel and the Red Crusader, and exhibited an attitude and conduct that were impeccable, according to the commission. So the significance of Red Crusader case is that by creating a tribunal, so it was, a commission, but somehow the commission was, the membership was not only technical people, but also judges and, esteemed honorable officers, right? By creating a tribunal whose primary concern was to establish the facts, the parties were able to avoid debating the full legal implications of the case. So they were just, pointing out of what was happening on the scene, right, on the event. Secondly, because the proceeding were in the form of an inquiry and not a trial, right, the outcome was a report rather than a award. So that was several cases that all of you could find in chapter 3 of your book. And now I think we will discuss the most complicated cases out of all of the cases in chapter 3 with Raka. Raka, are you ready?
Yes, Bu.
Yeah. Do you have your slides? Can you try sharing them?
Let me try to share it.
Yeah. Can all the students turn on their videos as support for Raka? Thank you.
Does it show anything?
It shows us.
Wait, it says you're presenting to everyone, but it doesn't. Does it?
Now it does. Okay.
Cool.
Very good.
I'm sorry, Bu Linda
Yeah.
and Raka. I still can't turn on my camera. It's still broken.
Oh, it's okay, Audrey. Yeah.
Thank you.
All right. All right. Everyone can see the presentation, right?
Yeah.
All right. Cool. So I guess I'll just start right away. Good afternoon, everyone. I hope all of you are doing well. So today's my presentation would be on the Lattelier and Moffit inquiry case.
Oh,
So
it's
that's like
Raka is a French name. It's Lattelier.
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 Lattelier and Moffit.
Moffit, yeah.
Lattelier and Moffit inquiry. And yeah, so on this presentation, I'm going to briefly touch on inquiry as a form of international dispute settlement itself, and then moving on to the case. And in relation to the inquiry itself, I think Belinda already helped with briefly touching upon what's inquiry. So I'm just gonna summarize it a bit. So essentially, it's a process that is performed whenever a court or other body endeavors to resolve a disputed issue of fact. And in this particular sense, the inquiry that we're going to talk about, it's more of an institutional arrangement of which states desire to have some disputed issue independently investigated, as opposed to a process of where it's a part of a larger judicial settlement. And to give it a more clear example of the institutional arrangement itself, it can be seen in the inquiry under 1899 convention as well as the 1907. But I'm just going to focus on 1899 here first to give a more of an example on what's the form of it. So it's essentially the inquiry that is regulated under Hague Convention would be in relation to differences of international in nature, which does not involve honor or vital interests, and it arises from a difference of opinion on points of fact. And the inquiry also deals with the questions of fact as opposed to law. And so this is a Washington Post newspaper on the headline with the Letelier being assassinated. So who are actually they? So Orlando Letelier is a former was a former foreign minister of Chile. So he fled to United States after the military dictatorship, as and with they were assassinated in a car with a car explosion bomb. I'm going to discuss that a bit later. So in the car there was also Ronnie Carpen Moffat. She was an American citizen, and along with her husband Michael Moffat. So what actually happened in the case? As I said before, there was a bomb implanted in the car and it exploded on in 21st of September 1976 in Washington D.C. So the explosion killed Letelier and Mrs. Moffat, as well as injuring her husband, Mr. Moffat. The relatives, as well as the estate of all of these people who are the victims, they brought proceedings against Chile in the United States, and they were actually awarded with 5 million. However, the judgment was not satisfied and it was rejected when they attempted to obtain an execution of the assets of Chilean National Airline because they believed that the assassination was Chile was responsible for this assassination, because some believe that the ones who planned the bomb car was like the political opposition of Letelier, who is currently in charge of the military dictatorship in Chile. So, what did the states actually do to help settle the dispute? In 1988, United States made an international claims against Chile, invoking the provisions of Miriam-Suarez-Mujica Treaty, 1914. So, the Miriam-Suarez-Mujica Treaty, and the formal name was a treaty for dispute settlement that for disputes that may occur between United States and Chile, something along of that. But the ones who signed it was Birian and Suarez, so some people refer to that. Essentially, this treaty somewhat referred to the 1899, basically the Hague Convention, as to resolving disputes through inquiry by setting up a commission. In this case, Chile denied responsibility of the assassination and the bombing, but they are prepared to make an ex gratia payment to normalize their relation with United States. And in 1990, both states conclude an agreement of which Chile was to make an ex gratia payment to the sum payable if the liability is established, of which where basically if Chile is liable for that, they would need to pay in that amount. And this is where the inquiry commission or the inquiry itself comes into play. So the amount that was going to be paid by Chile to United States on behalf of the families of the victim was to be determined by the commission, of which would be formed by the 1914 treaty. So the inquiry commission itself, they only have one role, which is to determine the sole question of how much the payment should be made. And in this case, as I noted before, Chile already agreed on the compromise and the agreement that they would wishes to make an ex gratia payment without admitting liability to normalize relations with U.S. And the amount that was going to be determined by the inquiry commission is in accordance with applicable principles of international law. This applicable principles, as the report stated of the inquiry commission report, it states that it covers loss of financial support and services, material and moral damages suffered, medical expenses directly caused by the attack. And it's also noted that Chile wishes that no other claims may be brought against them in either domestic court or international proceedings after Chile has satisfied the ex gratia payment. So the principles that is being used by the inquiry commission is the PCIJ Chorzo factory case, of which, and I quote, "A reparation must, as far as possible, wipe out all the consequences of the legal act and reestablish the situation which would, in all probability, have existed if that act had not been committed." So how is the calculations for the payment actually made? So the inquiry commission, they underlined the fact that they would apply the same rules of the fellow members regardless of their nationality. But what the things that they do examine is the things that I've mentioned before. So it's a loss of financial support, um, and then material and moral damages, as well as the, yeah, for the family members. One of the examples that I could uh, provide would be in to come up with this number. One of the things that they calculate, for example, um, for the loss of financial support for the families or Letelier. In this case, they seen on the conditions of what would Letelier do prior to his like demise up until what they are currently like thinking of what he will do. So they examine on how much income that he would make from 1976 until 1990, of which he expects that he would still live in the United States before moving back to Chile in 1990 until his life expectancy end in 2007, because Chile already turns from military dictatorship into democratic country back then. So that's what the calculation of the uh, payment that should be payable. So in the end, the commission amount to 1.2 million to be compensated for the loss of financial support to the family of Letelier. So that's essentially on how they examine it. So they take into account of various things before coming into the numbers, and in the end, the amount of in total in the amount of 2.6 million. And as reiterated before as well, it is noted that after Chile satisfied this payment, there are no other claims may be brought against Chile in domestic court or international proceedings. So then what is actually the value of inquiry itself and the usage of inquiry itself? So as seen before from the Lattelier and Moffit case, it shows that management of the inquiry is used for usually for management of relatively narrow range of dispute. So it focuses on just one fact usually, and it tackles on what actually happened to the fact, and just to make sure which is the correct fact. And it also employed right. And it also employed in cases where honor and vital interests are not questioned. In this case, if we can see from the Letelier and Moffat case, the case only concerns on how much payment should be made from Chile to United States. It does not question as to Chile is liable for the act and for the assassination, because it some sort relates to the honor of Chile of conducting like international crime, some sort like a terrorist attack of bombing in another country. So that was not questioned in this case. And then lastly, inquiry is also adaptable depending on the acceptable procedure of the state themselves. So it can be in the form of pure fact finding in cases such as Tiger inquiry, such as like what Bu Linda have mentioned before, where it only focus on one fact, whether it happens where. That's it. But then it also can be change it into how the state wishes it to be. In this case, it can be in the form of near arbitration, just like in the Rate Crusader or the Lattelier-Moffit inquiry. Why is it near arbitration? I think the book also helps to explain that it is referred to near arbitration because it's some sort of not similar to the previous inquiry, because one of the commission is already a jurist, so it's not particular purely technical, but it also one of the most important things that made it some sort of a near arbitration, because law comes into place in this case, because the inquiry commission also assess the general the principles that would apply in this case by applying the PCIJ Chorzo factory case in order to determine the numbers that should be payable. And thus it comes into question as well how it would differ from arbitration and inquiry, since it's already some sort of near arbitration in this case. The book also helps to explain that inquiry it's only focuses on one fact, so it does not discuss on the thorny legal issue if we go to like arbitration. So that's one of the main differences that can be taken, and also inquiry also does not focus on honor or vital interests of the states that was in contention. However, though that it seems that inquiry can be a very much useful settlement of mechanism to settle dispute, there are a few limitations of how it can be used for settlement of disputes. So one of the things that one of the limitation that is mentioned would be the situation in which the facts are open to different interpretation proves amenable to negotiation. So after the dispute arises, before moving on to say inquiry, the states already can resolve their dispute by direct negotiation. So yeah, that's why after direct negotiation, if it then fails, they can go to inquiry or like failure of diplomatic exchanges. But in this case, there's a lot of instances that where direct negotiation already satisfied the agreement. So that's why they didn't go through an inquiry. And secondly, there are also many alternatives to the traditional inquiry as set forth in the Hague Convention. So the traditional inquiry that I briefly touched upon before, it talks about the institutional inquiry, institutional arrangement of inquiry themselves. So this is different from, there are a lot of alternatives that inquiry that is happening right now. So this, for example, World Bank have their own inquiry mechanism, and then United Nations Security Council, United Nations Human Rights, and then even specialized United Nations body such as the International Labor Organization. They have their own inquiry, which very much differs from the Hague Convention. So I'm not the ones I'm talking right here, it's more of the traditional inquiry as set further in the Hague Convention, whereas these alternatives some sort falls under the UN inquiry in UN types of dispute settlement, which probably be covered, I think it was by Dea in the upcoming weeks. So with the existence of these alternatives, states like do not use the traditional inquiry similarly to the what Hague Convention mentioned. They go through with other types of alternatives, so that's why inquiry it's not very much used. And also one of the limitation that is mentioned is the unwillingness of state to have their account of an incident of their action challenged in international forum. So they seem like they just want to close their eyes of a certain action and don't want to be some sort seen attached with the case. So that's one of the things that that's why states does not choose inquiry. And one of the last things that made the limitation for the using of inquiry itself would be states prefer to refer disputes of international courts directly. So this is where they actually give a clear judgment, as opposed to usually it's form of a report and inquiry. So that's why there are a few instances where states prefer to go to direct international courts as opposed to inquiry, and hence the numbers of cases that is solved through inquiry it's quite low as opposed to settle with other types of dispute settlement mechanisms. And in this case, then there are special conditions in quotation that as somewhat needs to be fulfilled. And these special conditions would lead up to whether states would actually go through with inquiry or not. So these conditions, such as disputed is large on one fact and no other procedure is being employed. So essentially, it's just fact finding, not including, say, the stuff that is included in arbitral, such as evidentiary process and so on and so forth. So it's just the fact finding. And also, one of the hardest part, as the last one, would be the parties willing to accept their version of the events may be wrong, because the each of the states that in contention, they have different perspective of the case. So it's important for if the states who go through with inquiry, they must accept that, then they are willing to accept that their version of the certain incident may be wrong. So all of these three uh, special conditions, it's some sort of rarely happens all three. So that's why inquiry is not particularly used by a lot of states to settle their disputes. So yeah, that's all for my presentation. Thank you for your kind attention, and I hope it all clear things up, and I look forward if there are any questions or comments or concerns about the presentation.
Okay, thank you, Raka. Now, let's open the floor for questions. Is there any questions from the floor?
Can I ask a question?
Okay, Aldinia, please.
Just out of curiosity, actually, and because this is one of the methods of dispute resolution, which, well, in this class is the first time I've actually heard of it. So I wanted to ask about the role of is if there is even a facilitator in the process of inquiry, and if so, what is their role and how exactly do they help settle the dispute, or is it just the two parties that throw their facts around? So yeah, that's my question. Just a general inquiry question.
For inquiry themselves, the facilitator in quotation would be the commission themselves, and it actually depends on which regulation, I guess, they refer to. Because if they refer to Hague Convention, they have their own formulation on how the numbers of, say, inquiry commission that should exist. And whereas for this, the ones that they refer to in this case is the Birian Suarez Mirica Treaty, where they regulates that they have 5 commission, of which there should be one from each national, and there remains like one jurist, and so on and so forth. And the procedure also varies, I guess, but essentially the essentially through inquiry, probably they one of the things that they provide as in writing as to about their facts, and that's pretty much it. So for in Lattelier-Moffit, the United States provides their presentation on the facts of the case, and then Chile provide their own, and then if the United Nations want to provide their own, then the commission would assess it. So essentially, that's pretty much it. So it does not involve very long procedure, like arbitration where they have evidentiary process and so on and so forth. I hope that answers it, Anaya.
Yeah, it does. Okay, thank you.
Yeah, so there's no facilitator. There is a commission, however. But the commission does not facilitate anybody, like, does not facilitate parties like you would in negotiating or no, in mediating or arbitration, right? So the commission just do their job. Like, whatever the question that was forwarded to them to be answered, that's what they do. And usually the members are uh, consisting of the state parties who are in dispute plus neutral parties. So, so they have balance in there, but they don't like serve this, their states directly. They just there to answer the questions that are given to them to be inquired. Okay. Other questions?
I ask
Who is this?
Rahma.
Oh yeah, Rahma. Okay, sorry. Go ahead, Rahma.
Um, uh, Thank you so much, Raka, for the interesting presentation. I also heard inquiry only now that you've presented. So I noticed that inquiry is something for fact finding.
Sorry. Inquiry, we already studied during international law.
Okay.
So don't, like, students, please do not kill your lecturers by saying you only hear inquiry just now, because we already
I haven't
Not in length, probably, but we already mentioned them maybe once or twice during
Yeah,
international law.
sorry, Miss.
Okay.
So you mentioned that it's more about fact finding rather than questions of law, and I know that fact finding is an increasingly popular tool to respond to situations or disputes. I just want to ask, maybe it's very general, but I just want to ask, at what point of a dispute do you resort to inquiry? Is it like after negotiation or after mediation, or is it after you go to court or something like that? Because it's a very interesting international dispute settlement for me, and I would really like to find out more about it. And now that you've presented it, I think it was quite clear. But I just want to know how at what point do you resort to inquiry? Thank you.
Thank you, Rahma, for the question. I think from the book itself, it discussed a few cases, and it kind of varies. But usually, to my understanding, before going directly to inquiry, sometimes the states themselves have their have tried to some sort of try to diplomatic exchange or direct negotiation to see whether they can settle it directly, or there are a few instances where they go through inquiry directly from the case just to see which is actually the correct fact. So I think it's either they go directly to inquiry or they go through negotiation first before going to inquiry. So that's why it's actually one of the limitations for using inquiry themselves, because sometimes when they go through the negotiation first, the case already settled, so they didn't go through to the inquiry process.
Thank you.
Any other questions, perhaps?
Yeah, Raka, may I ask a question?
Sure. Wait, yeah, I think unmute. Okay, Ines, you can go first.
Okay. So two-part question. First is what exactly is the threshold or standard for vital interests and matters of honor? Within your research, if you have any idea on how states determine what is vital and what is a matter of honor. Secondly, a hypothetical. So being someone who probably already knows a lot more about inquiry than I do, as long as with their positives and negatives, do you think that the current dispute between America and China about the source of COVID-19 would be a good idea to implement inquiry? Because China is saying that America is the source of COVID somewhere in a state, and America is saying no, it's in China, and they know what they're doing. So yeah, do you think that it might be a good idea to implement inquiry in that case? So yeah, recollect.
All right. Thank you, Anis, for the interesting question. So in regards to the first question, it was for the honor and vital interest, right? So I think for the honor and vital interest, it varies from states to states on how they perceive on what matters, what seems vital for them. So perhaps one state seems that this matter would be vital and the other may seems that it does not. So essentially, I guess it varies from states to states from states and case by case basis. For example, for the Lattelier-Moffit case, it does not involve of the honor of Chile themselves. By Chile, it does not admitting liability of conducting this some sort of terrorism act of bombing in another country. So that's why by not involving the honor or vital interest of a state in that sense, so inquiry can be used. So I guess it varies from case basis, I guess. Yeah. I mean, for example, for the wait, was it dog, wait,
Dodger Bank.
Dodger Bank, yeah. The one that it does not say, for example, questions the capability on the honor of the military for that sense. So yeah, it varies from what case from case, or whether it's interest of the military of that state or the states themselves of on how they conduct things. And secondly, for the second question, whether inquiry for America and China, I think it's quite hard to actually implement this case for for example, wait, let me open it up again, the presentation. So from my research and I guess my understanding from inquiry, which is very limited as compared to Bru Linda and probably other people, one of the things that needs to I would like to again reiterate the special conditions. I feel like in order to use it again, whether the COVID issue can be determined to be used by inquiry, it kind of needs to fulfill all of these three sense. Although it can actually some sort of fulfill this one, the Hague Convention. So it's focused on these stuff. But aside from that, it also needs to fulfill the one. Wait, how do you this part? I think one of the things that would be very hard to do so for the case of China and America, should they go to inquiry, it would be the last one. That the parties willing to accept their version of events may be wrong. So I feel like this last part, the last one, parties willing to accept thingy, it's actually one of the things that very much would hinder should United States and China wishes to go through with inquiry to settle their dispute, because like they're both big countries and they have their high egos, don't want to be blamed for especially for an issue this big. So yeah, I think that's my answer for if that's what I think for if should inquiry be used for that case.
Yeah, very pragmatical, Raka. Thank you.
No, but I agree with Raka because I don't know if you guys saw it this morning. The debate, the presidential debate between Donald Trump and Joe Biden. I was like, my students can do better than these two geeks. I was like, why? Why the US has gotten, such low level of intelligence. So it was embarrassing. I was embarrassed as I'm not even American, but I was embarrassed watching it. I can imagine, my American friends, they'd probably be like, why are we here? Okay. Next question.
Hi, Bu. I have a question, if I may.
Yes, please, Bita.
Okay. First, when you said this morning, did you guys see something? I thought you were referring to the young diplomat that talks on Vanuatu. It kind of reminds me of you, just saying, because you discussed about it last year in international organization.
Right.
So yeah, I'm just gonna drop it right there. But the question is, for Raka, after hearing the presentation, honestly, inquiry for me feels like an ideal dispute resolution method because it relies on accuracy, and although in most cases it's determined to it's conducted to say determine a precise compensation, etc., etc. Do you think that to some extent it could actually harm the involved parties to an inquiry, because usually states would actually take advantage of the vagueness of the facts and would prefer it to be vague, in order for them to have a better standing at a negotiation. So do you think, like, to some extent, states are reluctant to conduct inquiry because they actually love the gray side of the facts, or?
Yeah. Thank you, Bit, for your question. So yeah, I think that's one of the things that made inquiry it's kind of hard to be implemented, and there's a low number of cases where inquiry is used. Because using inquiry would one of the parties would need to admit that they play some parts of of an incident, and they kind of be involved to what happened. So one of the things that I guess we can refer to was I think it's the book it's mentioned about the Korean South Jumbo thingy plane that was shot down by Russia. And in this sense, the international labor organizations conduct their own inquiry to see about the case, and they condemned on what happened. But Russia was like, no, I am not involved in this, and they were not like deal with that issue. So I guess in that sense, states themselves inquiry on using inquiry themselves. There are states that wishes to, as I noted before, they wishes to not like be involved in a certain incident, so they are still in the left left in the gray area of like they're not responsible for some sort. Because if they go through with that indeed with inquiry, they would be some sort of admitting and reaffirming of a certain fact actually happened, and they are actually um, some sort of related to that fact. I hope that answers it. Sorry if it goes round and round.
No, no, yeah, yeah, definitely. Yeah, can I
Yeah.
ask like one really quick follow-up question?
Go ahead. Go ahead.
So like since the state that are involved, like at the beginning before the inquiry is conducted, they basically already agreed that at some point the fact's gonna prove basically who's in fault more or not, etc. So like when the inquiry is done, like is there any way for a state to still deny the outcome of it? Say that at the beginning they agree that they might be in fault, but then they disagree with the fact finding result, and like is there any efforts that they could do to basically deny the result?
I think for in relation to result, because the usually in the form of the inquiry itself, it's more of a report, so it's more like recap of what actually happened. So the states themselves, I guess they can ignore it per se, because they're not like, because it's not like arbitration where they need to follow it. It's unless the states choose to do so, like the Red Crusader and the Lattelier-Moffit. But since it's a form of more of a report, I guess the states, if they don't want to follow through, although it's not like a good faith, they wanted to go through with inquiry, but then they change their mind, I guess they can do so, because the binding effect of the inquiry report, it depends from the states themselves whether they want to go through for that or not. But the inquiry report themselves, I guess it sets some sort of, I think somewhere I read on the journal, it says some sort of like historical laid down on what actually happened. But I guess the states themselves could like deny it, although other states seems that this what actually happened. I guess that's it. From
So it's because the results of inquiry are reports, and they're specifically like from the very beginning, it's not binding. So the parties know that it's not binding. So it's not, so it's nothing like arbitration that it's final and binding. It's not like tribunal. Uh, it's not even like mediation, because in mediation you agree to agree, right? In inquiry, it's even less pressure than mediation. But on the other hand, you also let this commission to go through your dirty laundry, right? So it does somehow show the vulnerability of a state in this specific case. And as we already seen, the submarine, the Tiger case, and the Dodger Bank, and the other cases that we've discussed. The case that Raka was discussing, the Letelier and Moffit, it was even already decided in a court that they were going to get payment, the families of Moffats and Letelier. But because Chilean government ignored, Chilean government ignored to pay the $5 million US arbitration award, and so the families decided to forward the complaint to U.S. state court. So this is when, and then the ball gets rolling, because it's government via government now. Like initially it was just families versus the government of Chile, but now it became, it escalated. And then the Chilean government agreed for inquiry. So, and then like in the end, the families get, ex gratia payment. So yeah, so inquiries can be good when there's stalemates and discussion in mediation or in negotiation, or even after court decision. If, when the states agree, when the parties agree. But if the states do not agree, like definitely between the US and China, they will not agree about anything, right? I don't think they will go to any sorts of alternative dispute resolution. not right now, and maybe not in the future. Considering the the impacts of the virus had become very worldwide, and if somebody has to pay, it would be very expensive. Everybody, like almost all countries already gone to recession, and if somebody went up and say, okay, this is, I done this, and then they have to pay damages to every countries, I don't think. Yeah, so the consent of the parties is important. So just to go through the process, so not to the results, not to the report, but to go through the process. Okay, other questions?
I have a question.
Yes,
Can I
Elkis?
ask? Okay, so I was actually largely surprised of the fact that inquiry only focuses on, what Aka said, one set of facts. If that's what you said, one set of facts, because it's so fact related, and there's no relatively no law that plays in it. I was wondering, how do you reconcile that one large set of facts with, if ever they were going to entertain, like the inquiry commission were ever to entertain remoteness or causal consequence? Do you need me to go into like remoteness?
Yeah, I think that would help.
Like, I don't know how to word this. Maybe Melina can help. But because like remoteness or speculative, especially in this case where they were going into, compensation and how much that, the party should be compensated, it's like, how do you figure like which facts or like which factors that are not related to each other be like as a result of that income, or it's like remote or speculative loss of income which cannot be linked to such activities. So like they're not really related, but they play into how much this person should be compensated. Now, if you're going to focus on the fact that inquiry only focuses on one set of facts, how do you reconcile like the inquiry commission entertaining which factor that it may be very different from one another, and therefore different facts could be linked to how much this person could be compensated? Does that make sense?
I guess. I'll try to answer if I understand the
Can I have
question.
Raka, she's showing off, Raka.
Oh, can I have a follow-up question to that? I mean, it's kind of related.
I'm sorry.
Can he answer first, because it's already somehow complicated? Nia, can you keep your question for next after this one?
All right.
Go ahead, Raka.
All right, I'll try to answer it, but I'm not quite sure if that would be correct. So probably Melinda could correct me on this one. So I guess in relation to how they're trying to reconcile with different facts to link it when one big fact, I guess it relates to trying to, though it's discussing on a fact, but sometimes it's not wait, I guess it's not particular sometimes distinguished from law as well. So for example, if we take it clearly on for this case, Lattelier-Moffit itself, the question was only on how much the compensation should be made. And I guess that's where the remoteness comes from, where they should compensate on financial support for the families, where they need to take other facts into account on how to determine the numbers, where how much payment should be made for the families of Lattelier, should considering if he is still alive up until life expectancy ends. So I guess that's the for the inquiry part, that's like the hard part, especially for this case, where they need to take into account, although it's some sort of speculative, but they are trying to make it some sort of the best speculative outcome, taking into account what he does right now and how might he do in the future. So although it's essentially it's still discussing on one that fact, but leading up to that fact, there are might other facts that plays into part which the commission have to deal with. Yeah, I guess that's it. If that answers your questions, I guess I'm
Yeah.
answering it
So
round and
I
round.
think Balkis, I think what Raka is trying to say, specifically what inquiry commission is doing, is to answer the questions of facts that are given to them. So not specifically just one fact, but like the questions that are given to them. For example, like the previous cases that we are talking about, the tiger, for example, they were asking whether it was done uh, in the high seas or in Spanish water, the event, right? So they didn't even ask who done it, how it was done, but just the place. And then for Letelier, the questions that are given to the commission was only how much that Chilean government should pay for the grieving families. So they didn't even, they didn't even question why the Chilean government should pay. If the Chilean government denies that they really plant the bomb, they shouldn't have paid anything, right? But it was not the question. The question is how much they should get, compensation. So the way that you formulate the question for the commission is also very important in inquiry cases. Because sometimes, like for example, the tiger case, it even the report of the commission of the inquiry was even became a base of the sequence of the proceeding after that takes place after the inquiry, which was arbitration. So the arbiter was taking facts from inquiry commission, and then they proceeds into legal proceedings. Okay, well,
Thank you.
okay,
Yes, that clears it up.
okay. Aldinia, you wanna?
Yeah. So my question kind of correlates with Malchus's questions in the sense that I also just discovered today that there is this mechanism that focuses only on facts of the case instead of also discussing the law. And my question to that is there an is there concepts such as independence and impartiality um, applicable towards the commission involved? Because independence and impartiality, at least in my understanding, it means that the third party who makes the decisions are not supposed to have a preconception towards either side, right? But however, in cases in the procedure of inquiry where one party may say A and another party may say B, and it may clash with one another. And I suppose in real life, it may also mean that the press is covering it and it's all over the news. Are these principles still applicable? Do they actually exist for this particular dispute resolution mechanism?
All right. Thank you, Naya, for your question. To that, I guess my answer would be yes. The impartiality and independence also applies to the commission, although we can see that the commissions usually consist of the states in contention, like one of each, and then one neutral part. But the persons within the commission have their responsibility to the commission and try to solve the dispute, and they do not bear the interests of the states that they are actually from. So I guess it's some sort of similar for, I guess, arbitration, when the persons, although they come from that country, but when they are an arbitrator, they need to be independent and also impartial from their states, just to focus on the case in question. I guess that will be my answer.
Mhm. That's good, Raka, I think. Are there any more questions? Or are we done? Today, Irina Oji and Audrey are quiet and not asking any question. Is that premeditated, or do you want to ask questions?
No, ma'am. The presentation is clear enough, so I think I'll save
Okay.
my extra
Yes,
info for
I
next time.
agree with Fuji.
Okay, so all of you are fine? All right. So thank you so much. Oh, I want to tell you something because I like all the recording, I put it on my YouTube, and our class last week on mediation was also on YouTube. And several colleagues of mine who doesn't work in UGM, who doesn't work in US, they contacted me and say like, wow, your class in NUS is really good. And I'm like, which class? And they're like, the mediation class. I'm like, oh, that's not NUS. So because you guys are so good, they think you're NUS students. Oh my god. I'm like, they are better than NUS students, right?
Honestly, we don't even look like Singaporeans, but I'm honored.
Okay.
Yeah, send my regards to your colleagues, ma'am. Thank you.
So I
Room
told
for
them that
development.
my UGM students are better than you. Well, it's recorded, so I probably shouldn't say that. Okay, so I'll see you next week. Keep up the good work. Excellent work for Raka. I'm expecting who's going to go next week? Aldinia, yeah.
Yeah, I'm going next week.
Okay, I'm expecting very high standard for Aldinia, and
Yeah.
and everybody else. So,
Good.
yeah, so I'm hoping WebEx will be resolved next week, and if not, this would be, the venue that we will meet again next week. Okay.